All right. Welcome to the second lecture for this class. This is January 14th, Thursday of the first week of classes. And as you can see, I've gone ahead and posted the first assignment for this class, which is the first one-page response paper. If you follow the instructions and format it appropriately, I don't think that the length is particularly intimidating. One page, double-spaced, adds up to about 350 words. Plus, it's over some relatively straightforward material in the textbook and material that I'll continue to discuss in this lecture. So go ahead and watch the rest of this lecture before you attempt at writing the response paper. In terms of the rest of the information in the first chapter, as well as some information from the second chapter, I will post some discussion boards for that. But for this sort of higher touch assignment, this response paper, it will be specifically over the intellectual property section in your first chapter. That starts on page 6, and the title is Licensing and Protection of Intellectual Property Rights. So let's jump into that topic in a little bit more depth. Your book mentions that intellectual property has 3 subcategories. And those subcategories are patents, copyrights, and trademarks. But they all fall under the umbrella of intellectual property, which is sort of based around the protection of ideas, okay? Specifically the commercial protection of ideas. What people want when they create something original, whether that original thing is an invention, that might be useful in the workplace or for selling to other people, or whether that original product is a musical performance or a movie script or a full-blown movie. People would like other people not to copy that and then to profit off of it. It is encouraging to artists and performers and actors and movie producers that they would have some type of exclusive rights over their original creation and exclusive ability to profit off of their original creation. Okay. So governments around the world, and the United States government as well, have gone to some lengths to protect the private ownership of ideas, which is sort of an interesting concept. So let's get into the specific definitions of what those subcategories are, starting with patents. Patents are an exclusive right of protection for an invention, okay, specifically for a piece of hardware or software. So everything from the iPhone or Android device that you carry with you, to a run-of-the-mill calculator, to a specific type of thermos that keeps beverages warm for 10 hours. Everything around you very, very likely has some type of patent, okay? Because for the most part, the products that we buy are inventions, okay? And it's particularly important to inventors and the companies that sell inventions that other companies not copy them. Specifically, a patent protects the inventor to having an exclusive right to keep other people from making, using, or selling their device. Okay? They have an exclusive right to keep other people from making, using, or selling their device. So let's say I were to sit here at this computer and I opened up a programming application and I invented a piece of software that does your taxes for you, okay? And I wanted to sell that software to other people because everybody loves to have a piece of software that does their taxes really easily for them. Well, I might have created something new, or I might have copied someone else. If I've created something new, then the patent office is going to approve my patent, and I can keep other people from copying my software. But if it looks an awful lot like I just copy and pasted the source code from TurboTax, then I may very well have violated their patent, and I would not be able to sell that product unless I want to be sued. Okay. So now let's talk about copyrights. Copyrights, to distinguish them from patents, are not necessarily over inventions or hardware or software of some kind. They're generally over some type of literature or art. Okay. Specifically, copyrights are an exclusive legal right given to the creator of the following categories: print, published material, performances, films, records, literature, art, and music. Okay. So those are the categories of copyrights. So if I were to write a novel, okay, if I were to write a book and I title it, let's say it's a murder mystery, and I title it The Copper Creek Killer, right? And I write several hundred pages about some type of really gripping adventure that some people go on to try and catch a murderer, right? That might turn into a really good bestseller, or it might flop. Who knows, right? But I probably, especially if I want to sell that book, especially if I want people to go buy it in a bookstore, then one of the first things I want to do is make sure that it's copyrighted. Okay. If I can't prove that I created this material, then somebody might copy and paste it and then go do a better job than me of selling it, right? So I want to make sure that I have that exclusive legal right. So there are a couple things I can do. One thing I can do is I can put a little symbol on that material. That's the C with a circle around it, the copyright logo, and put the date or the year that the origination of that copyright started. And that's my indicator to the world that I claim this document, right? For an extra layer of protection, because that's relatively weak proof to just put a little stamp on something in the year and then say, I made this. Um, as an alternative, I could just send it to the US government Copyright Office, who will then document it, document the date they received it, and they will consider that as evidence that I'm the originator of that idea. Okay. Finally, there's trademarks. Trademarks are the logos that are used for the marketing of products. Okay. So there are generally two types of trademark symbols. One is a corporate logo or a business logo of some kind, maybe an organizational logo for a nonprofit. Um, and then there are product logos. So companies might have any number of lines of products under their corporate umbrella that they want to market. So, say for example, you have a chemical company such as Dow Chemical, which obviously will have a Dow Chemical logo, but they might have any number of actual chemicals that they sell to companies that each have their own logos. Okay, so trademarks come in those categories, and trademarks also come in both the unregistered and registered format. You'd have to pay the government a little bit of a fee to send them a copy of your trademark that you would like to have registered. If you do so, then you can put the registered trademark logo on that logo everywhere that you put it. Okay, and that's the R with a circle around it that we see on so many logos. You might see it on the Walmart logo. You might see it on the Purell hand lotion logo. You might see it on any number of things, right? That R sitting right there next to that logo means that they have actually sent a copy of that image to the federal government so that they can keep that legal right to produce that image exclusive to themselves. Okay. And it serves as evidence that they have the ability to prosecute you if you steal their logo or if you substantially copy that logo to a certain extent. There's also unregistered trademarks denoted by the small letters TM that might come usually above and to the right of the product logo. Usually the TM is for limited run product lines or things that don't rise to the level of urgency that a company might care about their overall umbrella image a little bit more than smaller products. Now, it still serves the same purpose. It's claiming to the world that you have created this and you claim exclusive domain over the production and usage of that logo. You could be proven wrong, right? Somebody could go to court and say, actually, 30 years ago, someone else trademarked this, right? So it is always behooving to a company or to an individual to research the similarly existing logos that exist out there to make sure that they're not either intentionally or accidentally copying someone else. Okay? And then what kind of remedies exist for intellectual property? Well, obviously one remedy is to sue the infringer, the person that's inappropriately copying or reproducing that intellectual property, whether it be a movie, whether it be an invention, whether it be a logo. You can just sue them and say the court needs to give them an injunction to stop them from doing it. Okay, so you can stop them. That's one remedy. Remedy two is also in a court case against that person. You can ask for compensation for all of the profit that they received off of your original creation, right? So if let's say, and this would be an egregious example, but let's say somebody starts a website and they decide they're going to call it Netflix, right? Well, Netflix is already an existing website, right? But this guy comes up and he starts a website that he can't maybe get the domain name, so maybe it's Netflix with 2 X's, right? But he still uses the same logo. And it's, let's say it's also a similar service, that this is where you can watch movies online or order the DVD for a limited period of time, right? Well, of course, that person's going to be sued by Netflix, okay? And what Netflix is going to ask, of course, number one, is to make them stop, okay? Have the government make them stop, to discontinue that website. But number two, they're going to ask for all of the profits that person made until the enforcement mechanism was put in place. So if this guy's been running this subterranean Netflix website for a year and has made about $100,000 off of it, the pre-existing Netflix corporation is going to say, actually, that's our money now, because you have made money off of our logo, okay? Or at least a portion of that money would not have been made by the infringer if he hadn't used the trademark logo, right? So they're going to ask for restitution for those damages, okay? So those are the kinds of remedies. But when we're thinking about international business law, think about this. Does every country have the mechanisms in place to do that enforcement action, right? We know that the United States is a well-developed country. We know that we have a well-developed court system. We know that we have existing agencies in the federal government to enforce copyrights, patents, and trademarks. Not only that, but we have well-developed bodies of case law that go all the way back 100 years. Case law is pre-existing court opinions from many, many, many past cases of trademark infringement, copyright infringement, so that we can go back and look at those cases and see how they were decided and see on what basis the profits were redistributed back to the creator, right? Now, then we ask ourselves, does Venezuela have just as much of a well-ordered system to protect intellectual property, right? Does India? Does Western Sahara? Does Morocco? Well, they may or they may not, but we would be well advised to look into that if we plan on doing business in one of those countries, especially if we plan on doing business in one of those countries in an industry that relies heavily on intellectual property. If it were my job to go market Taylor Swift DVDs or CDs or music abroad, then I'm going to want to do business, especially in countries that have existing domestic agencies in their governments that will patrol and regulate those copyrights. Okay. And it would be risky, possible, but risky for me to do business in countries that don't have those enforcement mechanisms, because it's very hard to sue a person in a country that doesn't have a very well developed court system. Or if they have a court system with a backlog that goes back several months. Well, if my case isn't going to be put on their court docket for several months, then there is an interim period of time where the infringement is still taking place and still stealing my profits, right? So that might be of particular importance to a company that cares about their intellectual property. All right, so continuing a little bit, let's talk a little bit about licensing. Licensing is something that you have the ability to do when you distribute a product in an international market, but you want to give someone else limited control over that product or that idea or that whatever it is, okay? Whether it's a book, whether it's a movie, whether it's an invention, okay? You want to give somebody some limited control over that item, okay? A license will always have limits. So pretty common limits are things like, let's say we're talking about a musical production, or let's just say we're talking about a song, right? Let's say I work with a recording artist and his record label, and we would like this song to be on the radio in Egypt, okay? In fact, we think that if we put it on the radio in Egypt, we think it'd be very popular and we'd make a lot of money off of that song because, you know, when you put something on the radio, people listen to the radio and then you can sell advertising, right? So we think a lot of radio stations would love to buy our song, okay? So I'm going to license that song to Egyptian radio stations. I'm not going to give them the song. I don't want them to make money off of the song except the amount of money that they get as a result of the contract, right? I don't want them to be able to claim the song as their own. But I do want them to have some ability to use it. For example, the ability to play it on their radio station from time to time. Okay? So some pretty common limits on licensing are things like how many times can the item be reproduced? How many times can it be shown? If it's a movie, am I going to let them show it 6 times a day and sell tickets to 6 different showings? Maybe. Maybe I'd like them to limit it so that we're not diluting the market with the product. Okay. It can include things like what times is that product shown, or what may accompany a showing. So let's say, for example, I'm marketing a religious-based film, a Christian film, and I think it would be bad for the parties involved if it were shown in a venue of some type of moral disrepute, right? Can I limit what types of venues I would want the movie to be shown in? Sure, by contract, right? I can tell the foreign distributor of my music or my movie that I only want it to be put on these types of radio stations or in these types of movie theaters, right? I can limit the price that the product would be sold for. And I can limit how much of that profit would get to be kept by the distributor and how much of the profit would have to be sent back to me as the product creator and licensor, right? The licensee becomes an entity that has certain duties to me. I can limit how the product would be shared without a sale. So let's say, for example, we're talking about a license for a foreign theater company to act out a play that I wrote, right? Obviously, it's my intellectual property. If I wrote the play, then I'm obviously entitled to the giving of permission on whether or not people can act that play out and make money off of it, right? So let's say that in the front row, they want to give away a few seats for marketing purposes. It's just good. They want to just give away some seats to some scholarship winners or something like that. I might be okay with that. I might not. It depends on my business model. It depends on what I think is important for the buying and selling of my product. So I might include that in the license. Does this licensee have the ability to give away 16 free seats? Or am I going to say no? Any seat that you're going to have for this production is going to be a sold ticket, right? You can put almost anything in the license that you are legally allowed to, because it's your intellectual property. You don't have to offer a license at all, right? And then you might want to explore what can be the common penalties for the breaking of such a license. So if I'm selling a movie abroad, then I want to make sure that the license mentions what the consequences of the violation of its terms will entail. Does it mean that they will owe me damages, right? Let's say, for example, I share the audio file of a new song by an up-and-coming artist, and I share it with a radio station in Israel. And surreptitiously, the DJ at that radio station makes a copy of that audio file and he sends it to his friend who runs a file sharing website. Okay. And all of a sudden, I find out that this song has been released to the general public. Okay. High quality, high def, hi-fi. And all of a sudden, I'm going to be losing some money because now it's out in the general public. People are putting it on torrent websites, and there used to be websites that ran on a large scale for file sharing, things like LimeWire and Kazaa and Napster, if you had ever used those a while back, which were really venues for the illegal sharing of intellectual property, right? So the question is, can I force that radio station to owe me damages based on that inappropriate share? Okay, I probably can. I'll just put that in the license. For every inappropriate share, you owe me X amount of dollars, right? Or maybe we'll allow an independent auditing agency to determine how much profit I lost as a result of that share, and that will be how much you owe me. Or I can just go to court, right? So that could be a penalty. Another penalty could be refusal to do business with that venue ever again, right? Let's go back to the example of the author of a stage production, and somewhere in some other country they would like to perform that on stage for profit. Well, if they decide that they're going to put on a free play, right? That might be a violation of the terms and conditions of my license to them. Maybe I want to capture profit on every single production, right? So a consequence of that violation of the license, they put on a free play, maybe for promotional purposes or whatever other purposes, I might put in that license that as a consequence of that, they owe me the fair market value as if tickets had been sold, right? And that might hurt them a little bit, but that might be my right as a licensor. And then, of course, the consequence could just be that I don't do business with them ever again. Okay. So it's good. It's good to do business with countries that respect intellectual property laws. There are intellectual property treaties internationally. And it's important sometimes to check which countries have signed those treaties. And not just that, but which countries have both signed those treaties and actually have implemented mechanisms to enforce the content of those treaties. If you read the chapter, then you're familiar at least somewhat with the World Intellectual Property Organization, which came into existence in 1970 as a result of a treaty. Okay, it was the convention establishing the World Intellectual Property Organization. How's that for witty phrasing of a international treaty? And today, in the modern world, the WIPO is responsible for the enforcement of more than 26 other treaties on everything from patents to copyrights, intellectual property, special courts that exist to arbitrate international disputes over file sharing and infringement that might turn into even more egregious cases like outright plagiarizing, or you have a lot of Indian and Chinese companies that will very slightly change the logo of a company and sell products that seem or look or feel similar to the original creator but aren't actually, and none of those proceeds are actually being sent to the company that originated that idea or originated that product. So it's important to take a look at that. The U.S. Trade Representative, one of our offices in our government, U.S. Trade Representative, has warned our domestic companies against doing business with some specific countries because it just turns out that they have either no or very weak enforcement of intellectual property rights. Or sometimes they have very selective enforcement of intellectual property rights depending on whether or not it's a major company or a minor one. And some of those countries that the U.S. Trade Representative has warned American companies against doing business with include enormous countries like China and India, but also Indonesia, Russia, the Ukraine, and Venezuela. So we do have some countries that our government just warns domestic companies, hey, if you send a movie or anything, you publish your novel and you want to have it marketed in China, there's maybe not a whole lot China will do to protect your intellectual property. They might not ever stop a person from copy and pasting every word of your novel and then just selling it under their own name. Okay. So that's important. That's important for a domestic exporter to care about if they're going to put their product in the marketplace abroad. What are some other things that you might want to consider if you're in this situation? You want to consider specific domestic laws in foreign countries. For example, do they have a court system that even considers intellectual property? It's one thing to have a law on the books, but if their courts have never actually enforced that law, what good is it, right? Is there a deep backlog in their court system so that there might be a delay in your enforcement mechanism there? Does their court system have a history of granting injunctions? And then does their executive branch of their government actually have a history of enforcing those injunctions, even if a court grants one? So to put that another way, let's say you have a music artist in the United States. Let's say Shakira goes out there and creates this song and they're selling it in India. Well, then some Indian company copies the song and sells it not as Shakira, but as some other performer, right? And they collect all of the profits off of the replicated song. So Shakira goes to court in India saying, you need to stop this rip-off version being circulated of my song. It's stealing my profits. She might get a court injunction that says, yes, we agree with you. It should be stopped. But if the executive branch in India doesn't actually have any history of enforcing those injunctions, such as sending some type of government agent to the office of that other company and forcing them to stop or maybe arresting them, then what good is it, right? They're just going to continue to violate your intellectual property rights. So you have to look at these types of things in countries that you do business with. Another question is the history of their case law beneficial to the owners of intellectual property? There are some countries in the world that actively disrespect intellectual property, and they do it for economic reasons because they actually don't mind if someone copies the inventor of a product, if the product itself seems to have some value, or if the generic version of a product might be just really beneficial to their company, to their country. We see this in developing countries sometimes, especially with pharmaceuticals. Remember, a chemical can count as an invention. So if you're a pharmaceutical company that invents a measles vaccination, for example, and you go out there and you say, all right, this is ours. We capture all the profits from the sale, or we would prefer to. If in some developing country where measles is a particular concern, some domestic entity rips off that invention and just starts selling the ripped off version of the measles vaccine, their courts, especially if that's being sold for a lower price than the inventor, their courts might be hesitant to actually respect the intellectual property rights of the inventor if that's going to put their country at a disadvantage, or if it's going to result in it being harder for people to get their measles vaccination, right? So that's just an example to think about, and it's a real world example that comes up sometimes. Um, and then another question is, would a foreign exporter have standing before a foreign court anyway? There are some countries that don't even allow non-citizens to have standing before their courts at all. So that's not going to be a enforcement mechanism for you if you're selling something to another country that doesn't permit non-citizens to have standing before their courts and actually even seek an injunction at all. Um, Another thing to think about is, does that foreign government not just have a court system that's well developed on this, but do they have some type of piracy law that patrols cases of infringement? Or do they have an executive branch agency? United States has the FBI, right? What does Egypt have? What does India have? What does China have to actually actively investigate and patrol the infringement of intellectual property? Okay. Do they have a law against the online file sharing of copy and pasted data? What's to stop someone in a foreign country from copy and pasting every word of my novel and just posting it online? Can I seek something to have someone take that post down? If I can't, why would I do business in that country, right? Um, are there businesses in these foreign countries that have a history of respecting intellectual property and have other distributors distributed to them, and have they vouched for their honesty? Okay, that's one thing that's also important. A lot of exporters will just go ahead and share notes with their fellow exporters of intellectual property, and they will kind of do this on purpose so that they'll know which companies actually break their contracts, which companies actually end up attempting to hoodwink foreign exporters. Okay. And so you ask around at trade associations with other exporters, do you have a short list of companies that you have learned not to do business with? Radio stations that you know will not send you the full royalties checks that reflect the profits made off of a song. Okay. And then the very last inquiry is not to do with the domestic law of a foreign country, but it's the in-house patrolling part. If you are a domestic company that deals in intellectual property, let's say you're Disney or you are Warner Brothers, that's basically your product, right? You're creating intellectual property. So do you have a division within your business that actively goes out and searches for infringements against your product? This is something that the people at Warner Brothers or Universal Studios or Viacom, television channels, MTV, Comedy Central, they all have a team of people whose job it is to scour websites, to go onto YouTube and see whether or not their material is being reposted without authorization. So this is the real world example of this is, have you ever YouTubed something, a song or something, and you went to the video and the audio wasn't there? It had been taken down. That was very likely the result of the originator, the company that made the scene in a movie that you wanted to see on YouTube, asking YouTube to take it down. Okay. And a lot of file sharing websites, whether it be YouTube, whether it be Netflix, whatever. I mean, it could be Hulu, whatever. If they find out that something that they've posted is in violation of a company's intellectual property, they can very often just be requested to take it down and will. Okay. And one of the motivating factors behind that is, if they don't take it down, but they know it violates someone's intellectual property, they can sort of be aiding and abetting that violation, right? They're creating the mechanism through which the illegal action occurs. Okay, this is what happened to Napster back in the day, about 10 years ago. I don't know how long ago it was now, 15 years ago. you had file sharing websites that were taken down all over the place because they really existed for the exclusive purpose of illegal activities, sharing of intellectual property. Okay. So that's a little bit of discussion of IP. I hope that that lecture helps you a little bit in the construction of your one-page response paper. So go ahead and read the prompt and take a stab at creating the paper. If you have any questions, feel free to email me. My email address is mdavis@se.edu. You can also call me at 580-745-2392. If you've noticed, some of you have noticed that I've gone ahead and opened up the forum. In the forum section of the Blackboard module. And some of you have gone ahead and introduced yourselves there. I've created a forum for introducing yourself. Valerie, Stacy, Candy, Christy, and Regina have already posted there, so I invite everyone else that's in the class to go ahead and post your introduction to the rest of the class. Go ahead and read the introductions by your fellow classmates so we all know who's here. It's been fun so far, although we haven't done a whole lot and we haven't had any graded assignments yet. I set the due date for the first one-page response paper as next Wednesday, so you have plenty of time to go ahead and draft that and submit it. And we'll use that sort of as a test case. We'll see if everybody submits it on time. We'll see what the quality of the responses are, and I'll use that to sort of gauge where we go from there. Go ahead. At this point, you should have completed the reading of Chapter 1. Go ahead and at this point start reading Chapter 2 because I will create some forum discussion board questions that have to do with the material in Chapter 1 and Chapter 2 except for intellectual property, which is covered in the one-page response paper. Okay. All right. It's been a pleasure. You can expect the next lecture video to be posted on probably Tuesday or Wednesday of next week. So Tuesday or Wednesday of the next week of classes, that's going to be the 19th or the 20th. All right. It's been a pleasure. Thank you.